Good morning, everybody. Good morning, Chauke. Good morning, Madam. I'm looking around. I had hoped to see Advocate Batoy here to greet her properly, but I'm sure she will come later in the day. We apologize for the disruption. I think you all know that we are load shedded in Swani this morning, and we needed to attend to a few structural challenges and housekeeping issues with the builder and the coordinator. Thank you for making it to the venue despite this challenge with the electricity. We are going to start. Advocate Mutlamunyane, are you ready?
Thank you, Madam Chair. We are ready to proceed with the evidence of Advocate Shamila Batohi. But before we could do that, allow me to, with your permission, to do some internal housekeeping. Thank you, Madam Chair. I deem it appropriate to do what I colloquially call housekeeping for purposes of the smooth running of these proceedings, particularly with reference to bundles. Had it been in the High Court, we would have prepared a practice note that would inform a judge or whoever is reading as to what is it that is expected of the parties. I wish to draw your attention firstly to a supplementary affidavit which was filed the supplementary affidavit of Advocate Batohi in the bundle. You will find it
Council, we have it in our bundle.
Yes, I just wanted to draw your attention to that and the purpose for which it was filed. The purpose was to introduce an annexure which is referred to as Annexure 12. an annexure referred to as NJ5 was supposed to have accompanied Advocate Batohi's main affidavit, but was inadvertently omitted. And instead, a document referred to in paragraph 9 as NJ1 was the one that was attached to her affidavit, and it emerged later that NJ1 was not relevant for our purposes, and it has been replaced by Annexure NJ5. May I also draw your attention, Madam Chair, and
NJ1 is headed monetary and NJ1 is headed monetary and non-monetary awards.
that's the one,
That
Madam.
entire document.
That entire document is irrelevant for our purposes. And instead, it has been replaced by NJ5. But I need to draw your attention to the fact that NJ2 to NJ5 are collectively referred to as SB. Can I confer with my
Yes.
SB1? I'm reminded that it is SB1. SB1 is an annexure which collectively refers to NJ2 to NJ5.
Now you have SB1A083. Does it start there?
Indeed.
SB1A083.
It should start at 82.
SB1A082 is your NJ1.
Which we say was inadvertently put
Yes.
in the band.
So it can't start at SB1A082 because that very same 082 is your NJ1. It's marked NJ1. In other words, if we remove SB1A082, which is annexure NJ1, we start at SB1A083.
It will start at 1B, Madam Chair. If you may look at the amended index, SB1B is NJ2 statement by Colonel R.S. Ayer, which will be on page 088. SB1C would refer to NJ3. SB1D would refer to NJ4.
I am getting confused. Shouldn't we take a short adjournment for our clerks to help us to mark this document according to your file and to confer with Advocate Chauke's team?
Maybe we should do that,
Because
Madam.
what you are referring us to, that document that is marked monetary and non-monetary awards is your NJ1.
and SB1A in the amended index. It should reflect.
No, let's not go to the index. Let's talk about that page, because that's where the confusion is. I think we should adjourn
I agree.
so that you look at these documents. We'll request our clerk to come and help us. I'm getting more confused the more you try to explain.
Thank you.
Therefore, we will take a short adjournment, and once you have these documents properly paginated or indexed, then you'll come back.
Thank you, Madam Chair.
How long will it take to sort this problem out?
It should be not more than 10 minutes.
Not more than 10 minutes.
Not more than 10
It's
minutes.
5 past. We can reconvene at 1:15.
Indeed.
We adjourn. Thank you. Ramuthamanyane, we are really taken aback by the fact that despite the fact that you have such a big team, the record remains confusing. I would really expect that from the MPA side, we should be given a proper record. At least the pagination should be properly done. Look, we have expended about 30 minutes trying to correct what ought to have been corrected even before. Advocate Haley, you have a junior who should be assisting Mr. Mutlamayani and you with those basic things such as pagination and indexing. At least as far as I remember from my days of practice, that's what a junior does.
Thank you, Madam Chair. Madam Chair, this particular mistake arose out of having to work very late at night. I think we were close to midnight, where there was a mistake in adding a particular document. What ought to, with respect, what should have been a fairly simple matter of just explaining it, because it's a fairly simple matter to explain with respect. But the mistake happened. What we couldn't do is to simply remove documents without actually explaining to the tribunal how that mistake happened and what it is that we want to achieve. But unfortunately, mistakes do happen, but we do apologize for it. Madam Commissioner, if I could try and explain, because NJ1...
Let's not explain it. The fact of the matter is that the bundle is incorrectly paginated. And you do have a junior who should have done this job to assist the evidence leader, particularly because this is the bundle that comes from the NPA. You may, Madam.
Thank you, Chair. To the evidence leader and the NPA team, one would have expected that the junior would sit next to the evidence leader and assist him. For him to page through the file endlessly shows a lack of cooperation. And from a professional perspective, Advocate Lekgetho, I expect more from you. Advocate Mutlamayani shouldn't be paging through the file without assistance. Thank you.
Thank you, Council. I think we now understand one another. Let's begin. Let's begin.
If I may take it further and explain, because it is not only the document NJ1 vis-a-vis NJ5 where there was a mistake. There was also an omission about the last page of SB3, which is a memorandum from Advocate Chauke, which begins from 132 through to 228, as it appears on the amended index. The mistake that was done was the last page, which was signed by Advocate Chauke, was erroneously left out, and it was later discovered that this was done, but it is explained in the supplementary affidavit. It is now attached as SB 12. SB 12, which appears on page 283 of the paginated bundles, Madam Chair. I hope I'm not confusing. Indeed. on the extreme top right-hand side where it says NPA summary 1531, well, that is their markings there. Yes, whatever it is called, but I would prefer it be called SB 12-283 to avoid further confusion. Now, maybe something that needs to be clarified at this stage before we proceed any further, Madam Chair. The bundles that have been electronically filed by the NPA are massive and they've been marked. They've been giving tokens. If on a bundle the panel sees LO followed by a number, LO shall mean legal opinions. It's a bundle called legal opinions. If you see one that is PD with a number, 00300 and a number, it will be referring to policies and directives. In other words, it contains the prosecution policies and directives with the code of conduct there. CL shall refer to the one that contains case law. ZC shall be the Zondo Commission bundle. RM will be the Mdluli bundle. I asked what R means. They said Richard Mdluli.
You are too fast.
I'm sorry. I beg your pardon. Let me repeat myself. LO, legal opinions bundle. PD, policies and directives, which also contains the code of conduct. CL, case law. ZC, Zondo Commission. RM, Mdluli bundle, with reference to Richard Mdluli, Lieutenant Mdluli. B, poison bundle. That is all, Madam Chair. And CL case law. RM, Mdluli bundle. Yeah. R, Richard Mdluli. Yeah, let me explain NJ. NJ 1, 2, 3 to 5 were annexures to Advocate Andrew Chauke's annexures in her answering affidavit. It must have been in the review application that was brought in the Pietermaritzburg High Court, where Govan J delivered the judgment. Nomngobo, N for Nomngobo, J for Chiba. That then completes the explanation. Thank you. Then we may proceed.
You may proceed,
The
Councillor.
evidence. Can I then ask that someone call Advocate Patohi, please?
Good morning, Advocate Batohi.
Good morning, Judge. Good morning to the panel. Good morning to Advocate Chauke and his team. Thank you, Judge.
We must apologize to you that you were here the whole day yesterday, but we were unable to start with your testimony for reasons that are now obvious to you. And this morning also, because of some challenges, we are starting late. We apologize. Do you wish to take oath or to affirm?
I'm happy to take the oath, Chairperson.
You're happy to take oath. Do you swear that the evidence that you are about to give will be the truth and nothing else but the truth? If so, raise up your right hand and say, "So help me God."
I do, so help me God.
You may proceed, Counsel.
Thank you, Madam Chair. Good morning, Advocate Batohi.
Good morning, Counsel.
You deposed to a statement which we usually call an affidavit. And the affidavit is in front of you. Is that correct?
That is correct.
The last page of the affidavit has been signed, and it was attested to on the 14th day of November 2025. Do you see that? On page 81, the last page of the affidavit.
Yes, that is correct.
You confirm that the signature appearing thereon is your signature
It is.
under deponent.
Yes, that is correct.
You take responsibility of this affidavit.
I do.
You adopt it as yours.
Yes, I do.
In your opening remarks, is there anything that you would like to put before this tribunal as an opening remark?
Thank you, Counsel. By way of some introductory remarks, Chair, if I may. Thank you, Chair. Firstly, I'd like to say to this panel that it's not easy to refer a senior colleague to an inquiry of this sort, and giving evidence before this inquiry is not something I relish. Advocate Chauke is a colleague that I've known for a long time, with whom I've always had a professional and cordial relationship. I've discussed the subject of these allegations with him, not in any detail, but just explaining to him that as a national director, there's a duty that I have in certain circumstances. And I do believe that a full and transparent hearing like this will be in the interest of Advocate Chauke, as well as in the interest of the National Prosecuting Authority, to ensure that a fair and final decision in this matter is reached. Chair, very, very briefly, the Constitution and the National Prosecuting Authority Act, it requires all of us as prosecutors, including the National Director, to serve the people of South Africa only, impartially, in good faith, without fear, without favor, without prejudice. These are not just words, they mean a lot. And our prosecutorial independence is not a theoretical ideal. It is really a constitutional imperative. Very briefly again, because I will be testifying more about the Section 9 of the NPA Act requires that a national director, a deputy national director, a DPP be a fit and proper person with due regard, and this is the act, to the experience, conscientiousness, integrity, to be entrusted with the responsibilities of the office concerned. It requires persons to be objectively honest, upright, always seeking the truth. In other words, they, in fact we, must be persons of the utmost integrity who will act as the Constitution requires without fear, favor, or prejudice. That is the very fabric of what we are as prosecutors. Prosecutors in any country, on a chair, are powerful officials in a criminal justice system. They carry immense discretionary power, whether in determining to prosecute, who to prosecute, for which crimes. And in the circumstances across the world, there's always a risk that outside actors will try to improperly influence us. We must never succumb to this as prosecutors. The NPA we cannot fulfill our constitutional mandate if our decisions are vulnerable to pressure, direction, influence from external actors, be it from politicians, from the rich, from the powerful, from the private sector, the media, or civil society. As prosecutors, we must vigorously withstand such influence at all times. The decisions we take as prosecutors touch the lives, the liberty, the dignity of ordinary people. Every decision we make to prosecute or not can alter the course of a person's life, be it a person falsely accused or a victim deprived of justice. This is the reason why prosecutorial powers and functions must be exercised diligently, fearlessly, impartially, independent by every single prosecutor in this country and hopefully across the world. We lead efforts to uphold the rule of law. And any perception that there may be, and I repeat, any perception that prosecutions are politically motivated, selectively pursued or not, or improperly abandoned, they erode the legitimacy of and the trust and confidence in the entire system. So given the important work of prosecutors, it is why there are various instruments, which I will deal with in detail, that regulate and guide the functions and behavior of prosecutors. Start with the Constitution, the NPA Act, the NPA prosecution policy, directives, code of conduct, the United Nations guidelines on the role of prosecutors, the International Association of Prosecutors Standards of Professional Responsibility, and their statement of essential duties and the rights of prosecutors. These instruments, together with judicial pronouncements and the common law, emphasize that prosecutorial conduct must adhere to the requisite standards of integrity, of honesty, and we must be fiercely independent, especially from political or public influence, proceeding only, and I repeat, only where the evidence meets the required threshold, and maintaining public confidence through consistent, rational decision-making. This is the context within which the present case sits. I do want to deal with one issue that Advocate Andrew Chauke mentioned yesterday. He said that the case is legally defective and dangerously, I repeat, dangerously seeks to punish a prosecutor for exercising lawful prosecutorial decision. Chairperson, members of the panel, this cannot be further from the truth in this matter. This is about prosecutions that the testimony will reveal were it appears politically motivated, with, I want to say, no evidence. I think carefully about it because I do think there was no evidence to support one of the charges, or perhaps at the lowest level, if anything, but there was no evidence in my view to support one of the charges. And in the other case, it appears to protect them from being prosecuted when there was strong evidence in the matter. And so this is the context within which this matter is being dealt with, Chairperson. Thank you.
Let me refer you to the affidavit go to paragraph 3 thereof. You state there that the facts contained in this affidavit are, one, based on documents within my possession or under my control, which presuppose that some of the facts that you stated in this affidavit were not within your personal knowledge. If you may explain the context.
That is correct. Chairperson, members of the panel, all of these events that took place were before I took office. I was out of the country for almost 10 years. And so I have no personal knowledge of any of the matters that are referred to or the subject of this particular inquiry.
Are there any facts to which you have personal knowledge?
I'll have to think carefully about that. Most of the facts happened before I was here. I'm not sure if there's anything that I have personal knowledge of in this case.
But let's put it this way. There were encounters. You've had encounters with Advocate Chauke, not so?
Oh yes, we've been working together for the past 6 years.
So as far as your encounters with him are concerned, would you say you have personal knowledge of what was happening vis-a-vis his work?
From the time I took office, yes.
Yes. Okay. Now, you mentioned that you were in The Hague for about 10 years.
That is correct.
What had you been doing there, if you may?
Yes, sure. This year is my 40th year in prosecutions as a prosecutor. Most of the time has been served in South Africa. I was appointed as the senior legal advisor to the chief prosecutor of the International Criminal Court in The Hague in 2009 and served there until I returned to South Africa to take up the post of national director on the 1st of February 2019.
By referring to the Hague, are you referring to the International Criminal Court of Justice? I see.
No, not the International Court of the International Criminal Court.
The International Criminal Court.
Yes, not the ICJ.
Okay. Let's go back to your affidavit. You say in paragraph 5.1 on page 2 thereof, in paragraph 5 to be specific, actually, that you have structured your affidavit in a certain pattern, which appears in paragraphs 5.1, 5.2, up to 5.3.
That is correct.
For the moment, you may wish to begin with the mandate, which is where your affidavit begins. The mandate, the powers and functions of the National Prosecuting Authority and its functionaries. Without being seen to be repetitive, you've already briefly touched on that subject, but we deem it important that it has to be emphasized as to exactly what is the mandate of the prosecuting authority and what are the powers, functions of prosecutors, specifically DPPs, in the position of Advocate Chauke.
Yes, thank you, Counsel. I'll start with the mandate. So, as I mentioned previously, Chairperson and members of the panel, prosecutors play an extremely important role in the criminal justice system. In fact, as prosecutors, we are gatekeepers of the criminal justice system because without the intervention of prosecutors, the matters cannot proceed to trial. Firstly, Section 179 of the Constitution of the Constitution, read with the NPA Act, actually establishes firstly a single prosecuting authority in South Africa. And if we deal briefly with Section 179, 5 and Section 22 of the NPA Act, which is in paragraph 12 of my affidavit. The NPA, it determines and delineates, well, these acts, the Constitution and the NPA Act, sets out the powers of a national director. And in the main, these are, firstly, the NDPP must determine prosecution policy, issue policy directives, as contemplated in Section 21 of the NPA Act, which are to be observed in the prosecution process. The NDPP may intervene in any prosecution process when policy directives are not complied with, and a national director may review a decision to prosecute or not prosecute in certain circumstances. Those are broadly the powers of the national director. And there are various sections in the Act that further detail the functioning of the National Prosecuting Authority.
May I interpose that, ma'am, whilst you're still there? I deem it important that the powers, duties, and functions of national director should be read into the record as they appear in the NPA Act.
Can you refer me to the section, please?
Section 22. Section 22 deals with the powers, duties, and functions of national director. I may read it into the
I'm
record.
trying to find my act.
I'll
I
read
don't
it
see
into the
here.
record. Relax, advocate. I'll read it into the record whilst you are finding your copy. With your permission, Madam Chair.
Advocate Mhlamonyane, if I may interpose, shouldn't you look at Section 21C first, rather?
21C.
21C,
Uh,
which deals with the powers to continue criminal proceedings. 21C.
It should be 22C, Madam Chair. I
22C.
believe it 20. 20.
Do you have the act there?
I have the act here. 22(1) powers, duties, and functions of national director. 22(2)C, it's where a director may review a decision to prosecute or not.
Doesn't Section 21C specifically deal with the power to discontinue
21C.
criminal proceedings?
The Section 21, Madam Chair, doesn't have a subsection C. What has a subsection C is 22(2).
It is the affidavit that is conceived. 21. It is 21C.
21C.
Yeah. 20
Sub one.
bracketed 1
Oh,
C.
20
Yes.
in brackets 1. I was hearing it as 21.
Well, it appears
My
in the
apologies.
affidavit in 8.3.
8.3.
That's where I thought you should start. Just to lay the foundation. My sister is suggesting that perhaps you should be the one reading into the report. What do you plan to read into the report? Because she's the one who is speaking to her affidavit. That seems to be correct.
That I should read to
She
the
must read into the report her provisions, the
indeed,
provisions that she refers to,
indeed, I was
because she relies on them. So you can lead her and then refer her to those provisions. Then she can read the contents of those provisions she relies on into the report.
in fact I was going to do that as advised by my junior. She's just advised me to rather not get into the fray. Perhaps I was getting into the fray
Yes, madam, you are
unintentionally.
correct. Yes, thank you. No problem. Commissions of inquiries are not like court proceedings.
Indeed, indeed.
We are all learning.
Indeed.
See how we should do our best in executing our tasks. And for that, we are indebted to you, Madam Junior Counsel, and to my sister for reminding me to do that so that she is speaking to her affidavit.
Thank you, Madam Chair. You've now located your copy of the NPA Act, and I'll request you to proceed and read into the record Section 22, which contains the powers, duties, and functions of the National Director. Please do so.
Thank you, certainly. Perhaps Section 22 deals with the National Director. But if I may, through you, Chair, perhaps we should, given the direction and the guidance from the Chair, perhaps deal with Section 20 and briefly 21 before we go to 22. The Council has read Section 20 into the record. Does the Chair require that I do that again, Chair?
No, it is already on.
Sure. Thank you, Chair. Sure. Thank you, Chair. Chair, so Section 21 was read into the record. I will then deal with Section 23, which we will deal with in more detail later. Subject to the provisions of the Constitution and this Act, any director, referring to a Director of Public Prosecutions, shall, subject to the control and directions of the National Director, exercise the powers referred to in subsection 1 in respect of A, the area of jurisdiction for which he or she is appointed. This is important. And any offences, and B, any offences which have not expressly been excluded. Let me read it as it is in the Act. Any offences which have not been expressly excluded from his or her jurisdiction, either generally or in a specific case by the National Director. Subsection 5 of 21 is also relevant in this regard. Any prosecutor shall be competent to exercise any of the powers referred to in subsection 1 to the extent that he or she has been authorized thereto in writing by the National Director or a person designated by the National Director. The written authorization referred to shall set out the area of jurisdiction, the offences, and the courts. Section 21 deals with the prosecution policy and the issuing of policy directives. The National Director shall, in accordance with Section 1795, A and B, and any other relevant section of the Constitution, A, with the concurrence of the Minister and after consulting with directors, determine prosecution policy, and B, issue policy directives, which must be observed in the prosecution process, and shall exercise such powers and perform such functions in respect of the prosecution policy as determined in this Act or any other law. I suppose suppose the next relevant section, I suppose to highlight, I'm not sure that there's anything more in section 21 that I need to highlight. It deals with the issuance of directives by the National Director. And then section 22 deals with the powers, duties, and functions of a National Director. Section 22(1), the National Director as the head of the Prosecuting Authority shall have authority over exercising of all of the powers and the performance of all of the duties and functions conferred or imposed on or assigned to any member of the Prosecuting Authority by the Constitution, this Act, or any other law. And then I did deal with the next part of it. I did read that into the record. So I will not reread subsection 2 of section 22 into the record. I think those would be the relevant parts of section 22 for the current purposes. Council, I'm not sure if there's any other section you would like me, or subsection of 22, you would like me to read into the record for these purposes.
Yes, Advocate Chauke. If you look at section 22 in brackets 2, paragraph C, it's also important to be read into the record.
Perhaps I'll, for the sake of clarity, read section 22(2) in completely again. Well, not just this part of it. In accordance with section 179 of the Constitution, the National Director A must determine prosecution policy and issue policy directives as contemplated in section 21. B may intervene in a prosecution process when policy directives are not complied with, and C may review a decision to prosecute or not prosecute after consulting with the relevant director and after taking representations within the period specified by the National Director of the accused person, the complainant, and any other person or party whom the National Director considers to be relevant.
Now, under what circumstances, Advocate Chauke, would you, as the National Director of Public Prosecutions, review a decision to prosecute or not to prosecute? In practice, how would we go about it?
There is, I think it's section 20, I'm just trying to find the section that deals with the review, and I'd rather read that into the record. It specifically sets out the instances when a National Director may review a decision. If I could be directed to that. 24, is it 25?
Section 22(2)(c).
22, which I have read into the record, Chairperson.
Yes, you've already read it into the record, Dr. You've already read it into the record.
Yes, that's correct. If Council can please repeat the question.
My inquiry is, in practice, as a National Director of Public Prosecutions in the Republic, how would you go about reviewing a decision to prosecute or not to prosecute?
A National Director can decide to review a matter if it is a representation is made by any party to the National Director to review a matter, and the NDPP can review a matter if there's contravention of prosecution policy. And that's generally the way the trigger, the powers of a National Director in respect of review are triggered.
I'd like to take you to paragraph 13 of your affidavit, which deals with section 20, where you deal with section 22 of the NPA Act. You are referring in this paragraph to additional powers which are contained in subsection 3, subsections 3 and 4 of section 22. We will take the liberty, therefore, for purposes of completeness, to read into the record section 22, subsection 3 of the NPA Act, and then thereafter deal with those additional powers as you deal with them in practice, as they pertain to your duties.
So section, may I please interpose? It would be helpful if you refer to a paragraph in the affidavit itself, so that you can all zoom into that paragraph, and it will also assist the witness. I know for this purpose you refer to paragraph 13. It will be helpful if you can do that step by step, so that we can all follow where you are on the affidavit.
I take that I was still on paragraph 13.
You refer us to paragraph 13.
13, 1-3.
1-3.
Yes, and where she deals with
Additional
powers, and I asked her to read, for purposes of completeness and clarity of mind,
Yes.
subsection 3 of section 22.
It is my mistake. I thought that you simply referred to the word without saying that is in paragraph 13.
Paragraph 13, yes, I did that.
If I may.
May you proceed, therefore, to read into the record, Advocate Padohi, subsection 3 of section 22. You don't necessarily have to start with the main section 2, but subsection 3. And thereafter, you also read subsection 4 of the same section. Please do so.
Subsection 3 of section 22 reads as follows: where the National Director or a Deputy National Director, authorized thereto in writing by the National Director, deems it in the interest of the administration of justice that an offence committed as a whole or partially within the area of jurisdiction of one Director be investigated and tried within the area of jurisdiction of another Director, he or she may, subject to the provisions of section 111 of the Criminal Procedure Act 51 of 1977, in writing, direct that the investigation and criminal proceedings in respect of such offence be conducted and commenced within the area of jurisdiction of such other Director. And did you say 4 as well, Counsel?
I said 4 as well, and you'll then revert back to 3 after you shall have read 4 into the record.
Subparagraph 4, subsection 4 of section 22 reads as follows: in addition to any other powers, duties, and functions conferred or imposed on or assigned to the National Director by section 179 or any other provision of the Constitution, this Act or any other law, the National Director is the head of the prosecuting authority, A, with a view to exercising his or her powers in terms of subsection 2, may, sub 1, conduct any investigation he or she may deem necessary in respect of a prosecution or prosecution process, or directives, directions, or guidelines given or issued by a Director in terms of this Act, or a case or matter relating to such a prosecution or prosecution process, or directives, directions, or guidelines. B, direct the submission of and receive reports or interim reports from a Director in respect of a case, a matter, a prosecution, or prosecution process, or directions or guidelines given or issued by a director in terms of this Act. And sub 3, advise the Minister on all matters relating to the administration of criminal justice. B, shall maintain close liaison with the Deputy National Directors and Directors, the prosecutors, the legal profession, and legal institutions in order to foster common policies and practices and to promote cooperation in relation to the handling of complaints in respect of the prosecuting authority. C, may consider such recommendations, suggestions, and requests concerning the prosecuting authority as he or she may receive from any source. D, shall assist the directors and prosecutors in achieving the effective and fair administration of criminal justice. E, shall assist the Deputy National Directors, Directors and prosecutors in representing their professional interests. F, shall bring the United Nations guidelines on the role of prosecutors to the attention of the directors and prosecutors and promote their respect for and compliance with the above-mentioned principles within the framework of national legislation. G, shall prepare a comprehensive report in respect of the operations of the prosecuting authority, which shall include reporting on sub 1, the activities of the National Director, Deputy National Directors, Directors, and the prosecuting authority as a whole.
Allow me to interpose. You may exclude 2, 3, 5, and Roman 6. No, include Roman 6. Exclude 3.
So this report shall include reporting on the personnel position of the prosecuting authority. 4 would be, excluding 3, 4 would be any recommendations or suggestions in respect of the prosecuting authority. 5 is information relating to training programs for prosecutor. And 6, any other information which the National Director deems necessary. H, may have administrative work connected with the exercise of his or her powers, his or her functions, or the carrying out of his or her duties carried out by persons referred to in Section 37 of this Act. And I, may make recommendations to the Minister with regard to the prosecuting authority or administration of justice as a whole.
Omit 5. Go to 6. Omit subsection 5.
Subsection 6A, the National Director, in consultation with the Minister and after consultation with the Deputy National Directors and Directors, shall frame a code of conduct which shall be complied with by members of the prosecuting authority. B, the code of conduct may from time to time be amended and must be published in the Gazette for general information. 7, should I proceed with 7, sub 7?
For the moment, you may leave 7.
Mm-hmm.
Go to
8.
8.
The National Director or a person designated by him or her in writing may, if no other member of the prosecuting authority is available, authorized in writing any suitable person to act as a prosecutor for the purpose of postponing any criminal case or cases. B, authorize any competent person in the employ of the public service or local authority to conduct prosecutions subject to, I don't think this applies in this matter, but for the sake of completeness, I continue, subject to the control and directions of the National Director or a person designated by him or her in respect of such statutory offences, including municipal laws, as the National Director in consultation with the Minister may determine.
9.
9, the National Director, subparagraph 9, the National Director or any Deputy National Director designated by the National Director shall have the power to institute and conduct a prosecution in any court in the Republic in person.
For the moment, that will be all. Let's go back to Section 22 in brackets 2, subparagraph C. And I earlier indicated to you that I would like you to explain under what circumstances, as a National Director of Public Prosecutions, would you review a decision to prosecute or not to prosecute? In broad general terms, we may revisit this topic later on in your testimony, but for the moment, would you explain in broad outline how you go about reviewing?
So once a matter is referred to the National Director for a review, there is a section in the NPA, a business unit in the NPA called the National Prosecution Service, which is headed up by a Deputy National Director of Public Prosecutions. This is not in my affidavit, anywhere in my affidavit. This particular unit is responsible for all general prosecutions across the country. So the directors of public prosecutions would report to the national director, but through the deputy national director, who is the head of the National Prosecution Service. And the DNDPP, as I will refer to the deputy national director as of the NPS, has delegated power to deal with representations in terms of the Act, but all representations and reviews are processed through this office, and they would obtain statements from interested persons, affected persons, the DPP concerned, and they would then submit the file to the national director, and then the NDPP will then consider the matter. That is basically how the process of reviews are dealt with in the office. If necessary, in some instances, and well, I would, as the national director, I have appointed panels to assist in the review process, whereby the case will be presented to a panel, and that would happen on occasion if the matter is particularly complex.
If I may, counsel, and that will be for the purpose of deciding whether to prosecute or not to prosecute.
Generally, it is a representation that we receive mainly from accused persons, mainly. So once we get the accused would be requesting the national director to review and to withdraw charges. So the process would be to review it and to establish whether there is sufficient evidence to sustain a prosecution or not. So if the national director finds that perhaps there is merit in the representation, then it's possible that a decision could be made to withdraw the charges. On the other hand, if the national director finds that there's sufficient evidence to sustain a prosecution, then the decision would be that the prosecution must continue.
I see the provision 22 sub 2C speaks of to prosecute or not to prosecute. And you speak of a request to withdraw the charges. If you can assist me to understand these concepts within the framework of prosecution itself. I'm not sure whether withdrawal could be synonymous to non-prosecution.
Thank you, Chairperson. I'll deal with that. They are different. Non-prosecution is what we use a term called decline to prosecute. And that would be in instances where a docket is handed to a prosecutor for a decision. And if the prosecutor finds that there is insufficient evidence to meet the standard, which is reasonable prospects of a successful prosecution, then the prosecutor will decline to prosecute. And in that instance, the matter is not even enrolled in court. So that's decline to prosecute. But if a matter is enrolled in court, and then the prosecutor decides not to proceed with the matter before plea, and I emphasize before plea is taken, then the charges can be withdrawn. If for whatever reason, there may be representations, that is a withdrawal of a charge, but it has already been enrolled. If the prosecution the trial has started and the accused person has pleaded already, then that requires a stopping of the prosecution. And that is very rare that that happens. And my understanding is it requires the authority of a DPP to actually stop a prosecution. So a prosecutor in the courts cannot stop a prosecution. They can certainly withdraw matters, but they cannot stop a prosecution. They require the authorization of the DPP. So those are the three phases when a prosecution might not continue for various reasons.
Also, just to clear my mind, in the case of a withdrawal before pleading, when the matter is withdrawn, in that instance, does it mean that it can be reinstated?
That is correct, Chair. It can be reinstated in those circumstances.
At the practical level, withdrawals will happen, I suppose, where there could be insufficiency of evidence at that stage, before the pleading stage. Am I right?
That's possible, Chairperson.
It could also happen in instances where a prosecutor seeks to obtain certain information. Say, for instance, like in this case, and if I'm wrong, do tell me, where the prosecutor decide, I'd like to refer the matter first for inquest so that I can have a holistic picture regarding this aspect, maybe of murder.
Yes, absolutely, Chairperson. I want to hasten to add that later on I will explain why that decision was not the best in the circumstances, but that will be dealt with in a lot of detail. But to answer your question, yes, that is possible.
It's one of those maybe numerous instances where there could be a withdrawal before the pleading stage.
That is correct, Chairperson.
Which then means, for instance, in the case where the evidence was considered to be insufficient and later becomes sufficient, a prosecutor could then reinstate the matter. The prosecution.
Yes, if the evidence is indeed considered to be insufficient, can withdraw and then at a later stage reinstate. Correct.
Thank you very much, Counsel. I'm sorry to interpose.
You are at liberty, Madam Chair.
Criminal prosecution is complex.
It's very complex. You are at liberty to interpose at any moment that you would like to clarify your mind. I'm amenable to that situation.
Yeah.
Thank you, Madam Chair.
Yeah, I think at the time when you were asked questions, you were at a point when you were dealing with the issues of review by the National Prosecutor. And through delegations, this responsibility, as you have stated, is granted to the Deputy National Directors under that particular business unit. And you have also stated that over and above these business units, You also have the panels that are established for the purpose of dealing with reviews, especially in cases that are regarded as complex. Now, what is the position? I'd like to draw a parallel between the business unit that is headed by the deputies as against the panel that is brought in whenever, I don't know whether it's whenever a case is seen as being complex.
Yes, certainly I can explain that.
Yes, please do explain that.
Let me explain that the panels, if a matter is, I'm reviewing a matter, and as I said, it's particularly complex, or sometimes very high profile. So the reputational risk to the NPA is high, and we need to make sure we get the decisions right. As a national director, I would request that a panel be set up. The panel is actually an internal panel that is made up of very experienced prosecutors from wherever in the country that would sit as a panel and then consider the matter and make a recommendation to me in some circumstances. So that's essentially how, well, they would almost always make a recommendation. It would be very rare that they wouldn't, because that's the whole purpose of a panel. But it is an internal mechanism that I've put in place to assist in dealing with some of the more complex or high-profile matters.
Right, a follow-up to that. A decision whether to bring in the panels as against the business unit, does it lie solely with yourself? Is it within your discretion as the head of the institution, or what is the position?
If I am reviewing, as a national director, I am reviewing it, then of course I will request a panel to deal with it.
When this panel is constituted, is it constituted also with the participation of the deputy directors of public prosecutions, or is it, when you constitute it, you don't even consider taking members that are, one can say, for lack of a better word, automatically qualify by virtue of being in this business unit? Would you also rope them into this panel that you constitute, or you have a choice whether to do it or not? And if you have a choice, what are you inclined to do? Do you normally also rope them in, or does it become something that is dealt with exclusively by this panel that you would have constituted, on your understanding that the matter is either high profile or it's complex?
We don't have a hard and fast rule about that. Of course, I will consult with my deputy and we will talk about it. Sometimes the deputies will sit in and sometimes not. So it depends. There's no hard and fast rule about it.
In your view, do you think that, I'm trying to understand as to what informs this decision of involving the panel. In your view, would you do this because you suspect that there may be some deficit of competency in the business unit that would then bring about a need to constitute the panel? And if your answer is no, then maybe just bring us into understand as to what thinking brings about the establishment of the panel.
Sure. To answer your question, no, it's definitely not because of a deficit of competency at all. It is merely because, as I said, when a matter is particularly complex or high profile, it's better to have more experience and heads considering a matter than one. So that is the reason for having a panel of experienced prosecutors. It might be a very highly complex corruption, money laundering matter, and then I'll look for prosecutors in the NPA, together with my deputy, of course. Generally, they set up the panels with prosecutors that have particularly vast experience in these types of cases, and then get them on the panel so that they can consider the evidence and advise the national director. So that is the thinking beyond it, because it's also with very high profile and complex matters. You want to minimize the risk of getting things wrong. So it's trying to get more heads together to consider a matter. And of course, ultimately, it is the national director's decision. So the national director has got to consider it and take a decision on the basis of the evidence. So that is basically the reason for having this panel. And I suppose I should say that it's a kind of practice that one of the good practices that I picked up from my time at the International Criminal Court, where whenever a case was involved and was going to be enrolled or various, there would be a review committee set up where the experienced prosecutors in the office would sit together, team would present, just to consider the matter and to assist with gaps and things like that. So it was on that kind of thinking that I thought that would be a good idea to bring forward. And so we've tried to sort of institutionalize that kind of practice. So we also, and we've done it, I've spoke to you about it in the context of a review, but some DPPs also do it in their divisions where they have very complicated matters. They would hold a kind of review team where the team would present to the experienced prosecutors, and where these prosecutors would guide them and say to them, you have gaps here, let's look at this angle. And so that as a team, as a collective, you really make sure that you have a solid case when the matter does go to court. But that's at a different level. So we're trying to institutionalize that practice where we really harness the good experience and make sure we get the decisions right.
Just this last one. Over the period that you have served in the seat that you are currently occupying, has it ever happened that the personnel in the business unit would, once given a case to consider for review, they would then approach you to say that we think we need assistance. We cannot do it on our own and finalize. And we recommend that you beef us up as the business unit. Has it ever happened over the period?
Yes, we have certainly strengthened teams in the NPA.
Yeah, but did you hear the question? The question is, have you ever had a time where you would be approached by the business unit to say, we think we need to be supplemented or augmented, so we don't feel that on our own only we can carry this task, because we have identified that this task is quite complex, or it would be in the best interest of justice that you beef us up, because the case that you have referred us to or that we are dealing with is a high profile case. Has that happened? Basically on the request coming from the unit. Thank you.
Thank you. That's understood. Yes, it has happened when that has been the case, and we will consider, because one of the functions of a national director, one of this is to support the DPPs in the divisions, and there have been instances when that happens. We look at how we can support the teams. We have also resorted to the appointment of outside counsel in terms of Section 38 of the NPA Act to assist in a number of complex cases where they've come forward and said for various reasons the DPPs request that they require assistance, and then we have made lots of Section 38 appointments, as we call them. So that has happened, and we do, of course, want to try to support the teams as much as possible. So we do try to give them the support that they need.
Thank you.
Thank you, Madam Chair.
Proceed, sir.
Thank you, Madam Chair. Advocate Patohi, a few moments ago, Madam Chair was asking you about a withdrawal, which you dealt with, because she wanted to clarify her mind. She wanted to understand under what circumstances a prosecutor can withdraw. And you explained it. But there is also what is called provisional withdrawal. Can you explain that? As against perhaps a permanent withdrawal, if I may use that pun. It may not be used in prosecutorial circles.
Yeah, sure. Look, the practical impact of a withdrawal or a provisional withdrawal is zero. There's no practical impact because any withdrawal can be reinstated at a later stage. And so in instances where a prosecutor understands that there is a likelihood that I'm going to get more evidence, and you clear at that point that there's some investigations outstanding, and then you know that there's a good chance you're going to reinstate it, you would actually say it's a provisional withdrawal. But in instances even where a prosecutor withdraws a case, the point I'm trying to make is that once a matter is withdrawn, it can always be reinstated for any reason. Sometimes you may withdraw a case because the witnesses are not at court and the matter has proceeded for a while and the prosecutor decides, I'm not going to get another adjournment, realizes, so you withdraw a charge. And then you try to get the witnesses and whatever happens, and then you reinstate it at a later stage. So that's the point I want to make, is that there's no practical implications that are different, but you will provisionally withdraw in circumstances where you feel, and I'm repeating myself, that there's a strong possibility that you will reinstate if certain investigations or other requirements are met, for want of a better word.
Let's proceed and deal with paragraphs 15 for now and 16, perhaps a portion of 17. In paragraph 15 of your affidavit, you deal with section 22(6), which you have already read into the record. Where you are enjoined to draft a code of conduct, to frame a code of conduct, and policy. There is a code of conduct in existence, not so?
That is correct.
It's currently applicable to all the prosecutors and binding on them.
That is correct.
As well as a code of conduct.
Yes, that's correct. As you'll notice in terms of, in paragraph 15, in terms of section 22(6) of the Act, NPA Act, the NDPP is required to frame a code of conduct. And this was done, it was drafted and gazetted in 2010. In fact, I was fortunate to be part of a team before that, before I left. Well, in the early development of the code of conduct, I was, of course, out of the country by 2010. According to the preamble of the code of conduct, due regard was had to the United Nations guidelines on the role of prosecutors and the standards of professional responsibility and statement of the essential duties and rights of prosecutors, which I mentioned earlier on as well. And yeah, so there is a code of conduct in existence and it's binding on all prosecutors, including the National Director.
You also mention in these paragraphs the UN guidelines, United Nations guidelines on the role of prosecutors, which the law, the NPA Act, obligates you to bring to the attention of all prosecutors.
That is correct.
Was that done? And
It has been done in the context of the code of conduct. It's been incorporated into that.
maybe I should rephrase. Let me take you to F, 22, section 22, 4F. Are you there?
Yes, I see that.
It says, shall bring. The national director, as the head of the prosecuting authority, shall bring the United Nations guidelines on the role of prosecutors to the attention of the directors and prosecutors.
I see that.
Yeah,
And that has been incorporated into the code of conduct, which has been brought to the attention of all prosecutors, and they are bound to comply with it. So in that way, this has been complied with as it's incorporated into the code of conduct.
The code of conduct, as you set out in paragraph 15, is in the bundle policies and directives.
That is correct.
It also contains the prosecutorial policies, not so. It's a code of conduct.
Sorry, I don't understand that.
I'm saying in the bundle policies and directives, it contains the code of conduct as well as the prosecutorial policies, not so. Prosecution policies.
I understand it does.
Let us then proceed to paragraph 27.
Council, if I may ask, before we proceed there, if I could just emphasize something from paragraph 15
Well
on the code of conduct before we move off that.
and good.
It's on page 8.
On page
It's about
8,
5 lines down. The code of conduct emphasizes the professional conduct, independence, impartiality, and objectivity required of prosecutors in exercising their powers and carrying out their duties and functions. It emphasizes the role of prosecutors in the administration of justice and also the role of prosecutors in ensuring the fairness and effectiveness of the prosecution process. And then it goes on to deal with other aspects of cooperation with various partners. So I just wanted to highlight that aspect. Yes, thank you. You were saying, Council?
Yeah, it also mentions independence, which we will deal with later. The
Yes, that's
independence
correct.
of a prosecutor.
Absolutely, and that's critical.
Council, if I may, the policies and directions that you refer to that are mentioned in paragraphs 15, 16, and 17 are contained in a bundle, the index to folder marked policies and directives. Shouldn't we mark these bundles?
I beg your pardon, Malay.
Shouldn't we mark the bundles? We have bundles that you refer to us in your index. Now, at one stage, somebody is going to have to look for those documents. And these documents, the bundles that you see behind us, are not marked. I'm asking you that whether it is not appropriate at this stage, as you refer to them, to mark them appropriately.
In other words, if I understand, Madam Chair, clearly,
As
to be marked and also properly paginated.
I don't know about the pagination. I have my bundles, but this bundle doesn't have a name. It has a name, policies, and directives. Now, if anybody reads the record, is going to look for this bundle. Shouldn't we mark this bundle, perhaps refer to it as bundle A.
Give it a name, a tag. I agree.
It doesn't matter what you call it, but what do you
Yes.
call it? You may suggest to us. What do you refer this bundle of policies and directions?
May I confer with my junior? It's easier. She draws my attention to the fact that it's marked. Actually, it's given a name. It's
Just
named
tell me what the name is.
PD.
I beg your pardon?
PD. Whatever PD stands for.
PD.
Yes, PD.
Policies and directives.
Policies and directives.
So we must mark it PD.
It's all,
They-
yes.
PD.
Chair, at the end of, to help, if I may, page 8, and I know junior counsel might know better than I do, but at the end of paragraph 15, it says, marked, forms part of the record under bundles, policies and act, PD 00011 to PD 16. And these are these particular ones. I'm not sure if that helps, Chairperson.
It does help, but the actual document, you see what I have, and these bundles and bundles behind us are not marked. I'm saying, shouldn't we then mark them according to the affidavit? You understand what I'm saying, Council? The affidavit refers to this name.
SPD.
Yes, it's PD 0001 to PD 0016. I'm now suggesting to you whether we should not mark them accordingly. And I think as the evidence leader, you should then direct us or suggest to us that let's mark them accordingly, because we're going to mark other bundles. So this one of policies and directives of the PD 0011 to PD 0016. Which one, how do you mark this one? Should we mark it PD 001, policy directions?
I must give it a thought. I must give it a thought before I say it must be marked.
Please confer with your junior. You can switch off your mic so long. Maybe misunderstanding each other. Yes. No, they're not. Yeah. So the first to them on PD. Yeah. This one. This one.
Madam Chair,
That's what I'm saying. Suggest the same thing. That's what I'm trying to say to him. He doesn't understand. Please just
Yes, confusing around the.
Council, I see that you were conversing with your junior. And, you know, whenever we see problems, we don't just ask. At times, we also try to assist to the resolution of the problem. Now, I noticed from this batch, the batch of the PDs, the ones that are marked PDs, there are two batches, am I correct? There are two batches. Now, you'll have the first batch as 1 up to 68. And that would become PD1. And then when you go to the next batch in the series of the PDs, it becomes a PD2. So it's very easy to identify that from a distance. But if we are going to have these very many numbers, 1 to 68 and so forth, it's confusing. But to mark it there, up there with a marking pen to say, this is PD1, and the next one then will be PD2. And I know that you are going to deal with even many others where you have the LO, LCs and what have you. But it's just some advice. You are better suited to do it in a manner that you must be mindful of the panel, because at the end we have to draw the report. So whatever manner that you choose, I see the chair still wants to say something.
It's the second one.
It's 68, it goes to,
This one is up to 62.
okay, so this is one, this is two,
The correspondence.
there are two.
This one is correspondence. No, PD.
PD. Okay, Makili, oh, see. Let me see.
We are also experiencing problems. We are also experiencing problems here. But for our purpose, back to my question, we can mark your PD as PD1 to name this bundle. You are naming this bundle as PD1.
The
You
point,
can even say PD1 and dash PD 020 PD 0068 up to that page. Then we know that that page is complete. I see your junior counsel is nodding.
yeah, in
So
fact,
may we mark it that way?
in fact, Madam Chair, there was a suggestion that it be PDA, but we will go with PD 1, 2, 3, and 4, etc., etc.
Do you suggest that we use numerals or letters of alphabet?
Numerals.
Numerals.
Indeed.
I beg your pardon. Let me finish first with counsel, madam.
Numerals 1, 2, 3, 4, and so on and so on.
Yes. I think for our purpose, let's mark this document PD 1. This is the policies and directions.
Thank you, Madam Chair.
Thank you.
Chair,
Advocate
sorry,
Batoyi.
you seem to have taken a decision on PD1, and I don't want to confuse things more. My only concern is that these are page numbers, and you obviously got a PD1 somewhere, a PD2, a PD3, which are page numbers. So I would be inclined to propose, Chairperson, that we do in fact use the alphabet, and the first one is A, the first bundle. So it's PD1 to 6 of bundle, the PDA bundle, and the other one will be the PDB bundle. It's only a proposal. There are colleagues that have been working with these bundles. I haven't been, and I would expect that they will be able to guide better. But my concern is that if we use numbers, we might confuse it with the page numbers, which have a PD before it. That's my only concern. Thank you, Chairperson.
Actually not, council, because the numbers are 0001, 0002, etc. So you will say 1, then 0001. So I think the numbering, as we suggested, should then follow. So you'll have your policies and directions marked, bundle marked PD1. And we know what PD1 is. We took a long time to clarify this thing, but at least we know now. Kate Mutlamuyani, let this happen also with the other bundles, because it's going to confuse us when we are in the middle of this hearing, when people go back and forth referring to documents, because there are quite a lot and lots of records.
I take it, Madam Chair.
Before you proceed, Mr. Mutlamuyani, I see Advocate Batoyi. Did you want to say something, madam?
No, thank you, Chairperson. Not at all.
Thank you. I see it's 1:30. Council, it's 1:30. We propose to take a break for 30 minutes. That should be our lunch break. We will then proceed at 2 o'clock.
Thank you, Chair. we'll do that.
I
Chair-
hope it's not disrupting the structure of your evidence.
Not at all.
But we need to break.
Not at all. I need a break as well. Not at
Yes.
all.
Chairperson, can I ask that whoever's in charge of the aircons tries to strike a balance between keeping this place cool and not having it blowing really on the witness very hard? I'm freezing at the spot. Thank you, Chairperson.
Thank you very much, Councillor. We'll try to attend to that. They should get it right. I'm sorry for that. I'm sorry for that. I think the coordinator is here. She's going to attend to that immediately when we leave this chamber.
Thank you, Council. You may continue.
Thank you, Madam Chair. Okay, Patohi, I now direct our attention to paragraph 23 in which you deal with the prosecution policy. You tie that with paragraph 24 and 25 and in broad terms. Please elaborate.
Thank you, Council. So the prosecution policy in the NPA broadly deals with the prosecution process, including the essential role of the prosecutor and reviewing of cases. The purpose of this policy is to guide the prosecutors in terms of how they should exercise their powers, carry out their duties, and perform their functions. Further in the paragraph, the policy directives, I suppose maybe I should just outline the policy itself. The idea is to make the prosecution process fair, to make it transparent, consistent, predictable. And it's important that, prosecution processes are dealt with in this way. It's also, we want to promote greater consistency in the prosecutorial practices nationally. The policy directive the professional duties of prosecutors and operational matters affecting prosecutors and the other incidental functions, and not only dealing with purely administrative matters. The next paragraph deals, with including with factors to be considered when taking a decision to prosecute, and this is really important. So a decision to prosecute or not must be made in accordance with the NPA policy and the policy directives. The prosecution policy prescribes various factors that must be considered by a prosecutor, but apply equally also to senior members of the NPA, that is the NDPP, the DNDPPs, and DPPs. And these must be applied when we are deciding whether to prosecute or not to prosecute. And in essence, a prosecutor must have regard to the contents of the docket, that is, whether there's prima facie evidence and statements contained in the docket. We must also have consideration for any version proffered by the accused, in what is termed a warning statement that is taken by the police, or any confessions or any other statements made by the accused. We must, as prosecutors, evaluate the evidence, take into account all relevant factors, including how strong the case for the state is, whether evidence is admissible, the credibility of state witnesses, the reliability of evidence, and the availability of evidence. And of course, making the assessment at the end of the day on how strong a case is as a whole. On paragraph 25, we refer to the standard in terms of the prosecution policy in deciding whether or not to institute criminal proceedings against an accused person. The prosecutor must assess whether there is sufficient and admissible evidence to provide a reasonable prospect that when assessing a case as a prosecutor, there would be instances where reasonable minds could differ. And a prosecutor might take a view on the evidence, another prosecutor might have a different view. In that case, it wouldn't amount to irrationality as such. Sometimes in cases, judges take different views from prosecutors. You have benches that disagree. So it doesn't mean that it's irrational decision-making. It means reasonable minds can differ. But when it becomes irrational is when it goes completely against the available evidence, and a reasonable prosecutor would not have acted in that manner. That's when the issue of irrationality comes in.
Thank you. Let's proceed to paragraph 27 on page 15, where you make mention of the constitutional mandate of the NPA to prosecute, which carries with it an obligation.
Sorry, what paragraph, Chair?
27 on page 15 of the affidavit. Can you, in a nutshell, elaborate on this obligation? Because it talks about obligation, a constitutional obligation, but at the same time, a prosecutor has a discretion. Can you, in a nutshell, describe this obligation?
Yes. As I indicate in paragraph 27, there is a constitutional mandate. The NPA and prosecutors have a constitutional mandate to prosecute cases. And with it carries an obligation, which and there's been legal precedent on this as well, is that when the standard is met, we as prosecutors are obliged to prosecute these matters. And so unless there's good reason not to do so, and as I indicate on paragraph 28, there must be compelling reasons to withdraw a criminal charge, given our obligation as prosecutors to prosecute. There must be compelling reasons to withdraw charges when there is formidable evidence or when the standard is met with regard to pursuing a case. So in that sense, we have a constitutional obligation to prosecute unless there are exceptional circumstances to do otherwise. My apologies, Chair. It seems like they've switched the aircon off completely. So now I think they should try to strike a balance, Chair, through you to having it a bit lower, but now it's really hot in here. Thank you. My apologies.
It is a bit of a problem.
I think they've left the remote with me, so I have the power. Let me work this out. Thank you, Chair.
Got it right? Hopefully. When it gets too cold. Yes, thank you. Thank you, Madam. Might I take you, are you done with paragraph 27?
I'm done with paragraph 27, Madam
Yes.
Chair.
Might I just take you back to 26?
26.
It speaks of the prosecutor being satisfied that there is sufficient evidence. And it is expected that when there is sufficient evidence, then there will be a reasonable prospect of conviction, meaning that then the prosecutor will prosecute. And the paragraph then continues to say, unless the public interest demands otherwise. That's the aspect that I'm interested in. Unless the public interest demands otherwise.
Mm-hmm.
What will be such circumstances which will fall within the ambit of the public interest that will negate the need to prosecute?
That's an interesting question. Chairperson. There are various factors that a prosecutor might consider when deciding not to prosecute in the face of evidence that meets the required standard. There would be instances, for example, where there's a motor vehicle accident and a father is driving the car, meets an accident, and his child dies in the accident. And he's negligent. So do you prosecute the father who has really suffered a lot already, and there isn't a lot of damage to the other vehicle? You look at those factors and you think, on humanitarian grounds, this is a case that you don't prosecute, even though on the face of it, he was clearly negligent and should be prosecuted. There might be an instance where a victim or an accused person might be extremely ill, and you would decide that, or very old or very young, and you decide that you would not prosecute. So there's those kinds of factors that a prosecutor would consider. I must say that although this issue doesn't fall into prosecution public interest matters, that given the various constraints that we have with resource and things like that, it's literally impossible to prosecute every case. And so you sometimes have to prioritize matters and decides which cases to take on first. But that's, generally when a case is serious, and, we would certainly not prioritize other matters. It's more the less serious matters that would kind of fall at the bottom of the inbox, so to speak, in terms of attention. But it is a factor you have to consider, but it's not strictly speaking public interest issue. Well, it's not a public interest issue at all. Thank you, Chair.
Thank you, Councillor. That helps.
Yeah, just one thing. I'm actually made to ask a question because of your answer, where you were trying to explain as to what could constitute public interest. And then you went further to talk about prioritizing cases. Now, prioritizing cases cannot be an equivalent of deciding whether to prosecute or not. Am I correct? All what you are saying is that, depending on what we see or the importance of cases, others may find themselves ending up just being pushed lower and lower in the cycle. But how far do you go with that? Because every day there will be cases that we will see, criminal cases that we see as very important. And there will also be those that are seen as being, just light offenses. So up to how far do you then keep pushing these ones that are seen as just non-important cases?
So let me be clear, it's less serious, but not necessarily not important. Every victim or complainant wants his or her justice, even for the smallest of cases. And we have to be, as victims of crime we are lawyers for the people as prosecutors, and we defend the rights of victims, and primarily, but of course we must make sure that there's a fair trial and all of that ensues. But so we've got to strike that balance between, and look, the lower courts are full of those kinds of cases. It's not like we don't prosecute cases, the less serious cases. The district courts are full of them. So at the different levels, for example, the more serious matters, you may decide to choose, prioritize a matter because of the high profile nature, because of potential reputation, high impact matters. the matter that is reduction of harm issues that's also considered. So there are various factors that we consider in prioritizing, but it's not like there's a decision not to prosecute, as you correctly said, because of that prioritization. It's just that others will be prioritized over others. Thank you.
Thank you.
Thank you, Madam Ramaha.
Yes, thank you, Council. You may proceed.
Thank you, Madam Chair. Advocate Patohi, I now direct your attention to paragraphs 32, 33, 34. We'll deal with that later. In paragraph 32, you say, and that emanates from the provisions of section 179 of the Constitution. I don't think it's necessary for you to read into the record section 179(4) of the Constitution unless you deem it necessary. I think.
If we have I don't have the Constitution in front of me, but I'm happy to read into the record.
We have a copy here.
Thank you.
You can read into the record. Remember, we are here for the public and for the record.
I agree. Should we proceed?
You proceed, sir.
Advocate Patohi.
I'm just finding section 179. Okay, may I proceed?
Proceed, please, to read it into the record.
Thank you.
Just 179(4).
So section 179 is the part of the Constitution. It's headed the prosecuting authority. And so section 179(1), for the purpose of completeness, as the judge said, we are speaking to the public as well, creates a single national prosecuting authority, as I mentioned earlier on. And it deals with the structure in terms of the NDPP and DPPs. 179(2) is also important because it sets out the power. The prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out necessary functions incidental to instituting criminal proceedings. Subsection 3 states that national legislation must ensure that the directors of public prosecutions are appropriately qualified and are responsible for prosecutions in specific jurisdictions subject to subsection 5. Then subsection 4 reads, national legislation must ensure that a prosecuting authority, this is the important section you wanted me to go to, Council. National legislation must ensure that the prosecuting authority exercise its function without fear, favor, or prejudice. Subsection 5 then deals with the NDPP's function to determine, with the concurrence of the minister, and after consultation with DPPs, the prosecution policy, which we talked about, and subsection 5B talks, the NDPP must issue policy directives, which must be observed in the prosecution process. Going to 5C, it states that the NDPP may intervene, and this in the review process. And this was the section that I was thinking about earlier on. It is section 179(5)(c) of the Constitution, which gives the NDPP the power to intervene in a prosecution process when policy directives are not complied with. And D, may review a decision to prosecute or not to prosecute after consulting with the DPP and taking representations within a specific time from the following persons: the accused, the complainant, any other person or party whom the National Director considers to be relevant. Should I continue with the other subparagraphs? And the national legislation referred to in this section is, of course, the National Prosecuting Authority Act.
I want us to place our utmost attention to the terms used in subsection 4 of section 179, which you refer to in these paragraphs, at least in the two that has been referred to, that is 32 and 33, wherein it is required of a prosecutor to exercise his or her discretion, or when executing his or her functions, to act without fear, favor, or prejudice.
So as I indicated, section 1794 of the Constitution provides that the NPA must exercise its functions without fear, favor, or prejudice. And the Constitutional Court has held that in terms of this provision, there is a constitutional guarantee of the independence of the prosecuting authority. And any legislation or executive action inconsistent with this would be subject to constitutional control by the courts. Section 32(1)(a) then of the NPA Act carries this obligation forward and provides that all members of the NPA must serve impartially and exercise, carry out, or perform their functions, duties, and perform their powers, duties, and functions in good faith without fear, favor, or prejudice, and subject only to the Constitution and the law. And taking this further, subsection B of section 1B of section 32 further states that that subject to the Constitution and the Act, the NPA Act, no organ of state and no member or employee of an organ of state, nor any other person shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out, or performance of its powers, his or her powers, functions, and duties. And in the NPA Act, section 41(1), in fact, proscribes the contravention of this section. And as I said, these provisions give effect to section 1794 of the Constitution in terms of guaranteeing the NPA's independence.
These phrases, fear, favor, or prejudice, reverberates throughout the NPA Act as contained in the Constitution. Can you put them within context? What is fear? When can we say a prosecutor fears? When can we say a prosecutor favors? When can we say a prosecutor is prejudiced?
So I think the latter two are a bit easier to deal with. Favor is, of course, where you don't prosecute someone because you know the person for whatever reason. You know, it could be a friend, it could be a colleague. You favor that person. It could be a member of the executive. So that is, it's not prosecuting without favor. Prejudice, of course, would be the opposite. If you prosecute persons that you should not be, that would clearly cause prejudice to the persons concerned. The aspect of fear is, of course, it's meant to convey that in making our prosecutorial decisions, we should be fearful of nothing. You should not be fearful of the fact that you might be targeted for any reason, the fact that a member of the executive might victimize you. You have to do your job and base your decision on the evidence that is before you. Having said that, I must say, although prosecutors still I certainly hope that the majority of prosecutors in the NPA do exactly that and understand their oath of office to do this, an oath that we take in terms of the code of conduct. I must say that the circumstances in South Africa this day lead many people to become fearful for the work that they do because of attacks on prosecutors, witnesses, etc. But the concept of fear in the context of the Constitution is, as I indicated earlier, that we base our decisions only on the evidence in front of us in the docket, and we don't allow any fears that we may have for some of the consequences that I spoke about earlier to affect our decision to prosecute. In fact, if a prosecutor is fearful for any reason, and it's not unthinkable that may happen, then the prosecutor should inform the supervisor and withdraw from the case, but not take a decision that might be influenced by this fear in any way. Thank you.
Doesn't it follow then that if the prosecutor is fearful, he or she is not fit to hold the office?
Fearful in the context of the consequences I first mentioned, I would certainly agree with that. But the conditions that we're working on, if they're fearful because of threats on their lives, then of course it doesn't mean that they're not fit to do their jobs. We have to look at security. There might be really good prosecutors that are threatened. But if a prosecutor is fearful in the first context and then takes a decision on, I fully agree, they're not fit to hold office.
Proceed, Councillor.
Thank you, Madam Chair. Let us now focus our attention on the subtopic contained on page 19 of your affidavit, where you deal with the structure of the NPA. Briefly, just explain it in accordance with what is contained in section 179, 1 and 3 of the Constitution. Just in brief.
Yes, thank you, Council. So in terms of the Constitution and that section 179, 1 and 3, and the NPA Act, section 5 and 6, the structure of the prosecuting authority is essentially, as it says, there are two offices. You have the Office of the National Director, and then you have the Office of the DPP in the provinces.
Hold it there. Let me interject you.
Mm-hmm.
Let us explain fully what a DPP is.
Yes. So there's a Director of Public Prosecution, and Chairperson, you'll note in paragraph 36, I refer to section section 6 DPP. And that is specifically mentioned because the section 6 DPP is what will be the provincial head in the structure. But there are other special DPPs, special Directors of Public Prosecutions, that are appointed, and they are generally based at the head office, and they have a specific area of work. For example, we have a special DPP in charge of specialized commercial crime units. We have a special DPP that deals with priority crimes, for example, the TRC matters. Well, no, not the TRC anymore. That's been removed from this particular unit. But looking at terrorism matters, looking at international crimes, there's a special Director of Public Prosecutions. So that and of course we have the investigating director now, who is also at a DPP level, but is the head of the investigating directorate against corruption. So the section 6 DPPs it's dealt specifically with in paragraph 38. Perhaps I'll just deal with the National Office of the NDPP to start off with. This office is at the head office on paragraph 37, is at the head office and provides that the office of the national director consists of the national director, the deputy national directors, the investigating director, and special directors that I mentioned, other members of the prosecuting authority, for example, deputies, senior state advocates, prosecutors, all at the national office, as well as an administrative component. And then in paragraph 38, we move on to the office of the DPP, which is established at the seat of the High Court.
Allow me to interject you. It will follow, therefore, that Advocate Chauke falls under the category of a Section 6 DPP.
Yes, that is correct, because he is the head of a province. So he is a Section 6 DPP, South Gauteng Division. And so a DPP office is established at the seat of the High Court, the provincial divisions of the High Court, and local divisions of the High Court. And as I say, they may be referred to as Section 6 DPPs. So this Section 6.2 of the Act provides that the DPP office consists of the following: of the head of the office, who's either a DPP or a deputy DPP. And maybe I should just explain the deputy DPP aspect. For example, in KwaZulu-Natal, you have a DPP in Pietermaritzburg, the seat of the provincial division of the High Court, and you have a local division. You also have a DPP office, but it's at the local division, and the head of that office is a deputy DPP, but who, of course, will report to the DPP in Pietermaritzburg.
Whilst you're on that, Advocate Batohi, you mentioned that Advocate Chauke heads the South Gauteng
That's correct.
Division in Johannesburg.
That is correct.
There is a North Gauteng, in other words.
That is correct. That is in Pretoria.
You may proceed.
So the office of the DPP, Section 6 DPP, consists, of course, the head of the office, deputy DPPs, prosecutors, senior state advocates, junior state advocates. And the DPP also has jurisdiction over all of the prosecutors in the lower courts that falls within the DPP's area of jurisdiction. And we refer to Section 24 of the NPA Act.
Excuse me, Advocate Batohi, I think you are leaving us behind. I'm a bit confused about the Advocate Chauke being a Section 6 DPP South Gauteng, meaning Johannesburg. Does it, and then Pretoria jumped in. Can you assist?
Yeah. Gauteng province has two divisions. Johannesburg, one in Johannesburg, which is referred to as a local division. Not so.
That's correct.
There is a provincial division whose seat is in Pretoria.
That is correct.
It also has its own Section 6 DPP.
That's correct. So can I explain further? Maybe I can just try to clarify. This is one of the few provinces that has got two DPPs. It used to be the same in Eastern Cape, where there was a DPP seated in Mthatha and another DPP seat. So in Eastern, both in Eastern Cape, one in Mthatha, one in Grahamstown. And that's historic. I think it's also historic that Gauteng has two DPPs, as council has explained. So in Eastern Cape at the moment now we've kind of amalgamated and you have one DPP, but the same has not happened in Gauteng. But I suppose the demarcation process will deal with that. But for now, I don't think there's any, I'm not aware of any plans to have one DPP in the Gauteng division.
What is the position, not occasion, but the fact that we have two 2 seats of the High Court in Gauteng.
That is also, we do have 2 seats of the High Court.
You will therefore have a DPP South Gauteng and a DPP North Gauteng.
That is correct, Chairperson.
And if I'm correct, Advocate Chauke will be a DPP for the South Gauteng division.
That is correct, Chairperson. And the office is situated in Johannesburg, but the division, of course, is much broader.
Just a follow-up. So in the case of Gauteng, we have 2 DPPs, Pretoria seat and the Johannesburg seat. Now, in respect of KZN, do you have 2 DPPs or do you have a DPP and an NDPP?
You're not an NDPP, you have a DPP in Pietermaritzburg, which is a provincial division. And in the local division in Durban, you have a deputy as a head of that office. There's no 2 DPPs in KZN.
Okay.
It's
so-
1 DPP for the KZN province.
Right, thank you.
Sir?
Thanks, Madam Chair. Let us now leap over to page 21.
I should maybe, sorry, Council, if I may, just
Yes, you
before
may.
I was dealing with section 38 with the office, I want to point out section 38 in terms of section 38. We can also, and we could go to the section 38 of the Act, which I have the NPA Act. If I may refer to that quickly, Chairperson. I was asked a question earlier about additional support, and just to bring to the attention of the panel that section 38 of the NPA Act allows for the appointment of outside counsel where the need arises. The NDPP may, in consultation with the minister, deputy, that's 38(1), and director, engage under agreements in writing persons having suitable qualifications and experience to perform specific services in specific cases. So just to explain that is where external counsel are appointed in terms of that section. And of course, the DPP's office also has an administrative component, which consists of HR, finance, security and risk, communications, and other related administrative sections.
Are you fine with that? Let's leap over to paragraph 42, where you deal with the National Director of Public Prosecutions. Let's go to the Act. Before we get into this one, let's go to the Act. Section, I'll tell you, 24. I'll ask you to read into the record section 24. Section 24, subsection 1AB, CD, 2, yes, up to 2, for current purposes.
So section 24 is headed powers, duties, and functions of directors and deputy directors of public prosecutions. It relates to the functions of DPPs and deputy DPPs. Subsection 1 of section 24 states, subject to the provisions of section 179 and any other relevant section of the Constitution, this Act, any other section of the Constitution, this Act, or any other law, a director referred to in section 13(1)(a) has, in respect of the area for which he or she has been appointed, the power to institute and conduct criminal proceedings and to carry out functions incidental thereto, as contemplated in Section 23. B, supervise, direct, and coordinate the work and activities of all deputy directors and prosecutors in the office of which he or she is the head. C, supervise, direct, and coordinate specific investigations. And D, carry out all duties and perform all functions and exercise all powers conferred or imposed on or assigned to him or her under any law which is in accordance with the provision of this Act. Subsection 2 of Section 24 reads, in addition to the powers, duties, and functions conferred or imposed on or assigned to an investigating director. Well, I'm not sure subsection 2 is relevant unless the chairperson wants me to read it, because that deals specifically to the IDAC, which is not the subject of this inquiry.
I agree. I'm with you. Just skip it.
Subsection 3 deals with the special DPPs that I mentioned as well
Yes.
earlier on. Perhaps subsection 4, in addition to any other powers, duties, and functions conferred or imposed on or assigned to him or her by Section 179 of the Constitution, this Act or any other law, a director referred to in Section 13(1) shall, at the request of the National Director, submit reports to the National Director or assist the National Director in connection with a matter referred to in Section 22(4)(a) Roman 2. B, shall submit annual reports to the National Director pertaining to matters referred to in Section 22(4)(g). C, may, in the case of a director referred to in Section 13(1)(a), give written directions or furnish guidelines to the Provincial Commissioner of Police, referred to in Section 207(3) of the Constitution, within his or her area of jurisdiction, or Roman 2, any other person who within his or her area of jurisdiction conducts investigations in relation to offenses, that's AA, or BB, other than a private prosecutor, institutes or carries on prosecutions for offenses. And D, shall, subject to the directions of the National Director, be responsible for the day-to-day management of the deputy directors and prosecutors under his or her control. Should I read subsection 5? Sorry.
For the moment, you may skip subsection 5 and 6. Jump over to 8, subsection 8.
Subsection 8 of Section 24 reads, the powers conferred upon a director under Section 21 shall include the authority to prosecute in any court any appeal arising from criminal proceedings.
I want to take you back, Advocate Patohi, to Section 24.
To which section? 24.
24. Not in its entirety, but 24(1). I want you, for the benefit not only of the panel, but for the benefit of anyone who, beg your pardon, who interprets this section, to clearly understand what it entails. And I'll refer you to the phrase that I want our attention to be directed to. After Section 13(1)(a) in subsection 1, there's a word there that says has, and it has a comma. It says, after the comma, it says, in respect of the area for which he or she has been appointed. That is crucial. It is important, and one must, when one reads this, must read it with an eye of a hawk and with caution. Can you comment?
Yes, so Chairperson, this section 24(1) makes it clear that a DPP must exercise his powers or her powers and functions in respect of your area of jurisdiction. So the words in subsection 1, which says in respect of the area for which he or she has been appointed, a section 6 DPP is appointed to a particular jurisdiction. For example, it would be KwaZulu-Natal or the Free State, and that DPP is able to exercise, has the power to exercise functions and duties with regard to that particular area of jurisdiction. You can do all of the things below that are listed in subsection 1A, B, C, and D of section 24, provided that it is in respect of the area for which the DPP has been appointed. So that is a very important jurisdictional issue. You have no power to do that in another area or a case that is in another jurisdiction.
Thank you. We know that in law, for every rule, for every general rule, there are exceptions. Are there exceptions in this instance? If any, can you explain them, how they come into play?
No, I'm not aware of a DPP. I am not aware of a DPP of one jurisdiction exercising powers in another jurisdiction. In fact, if I'm not mistaken, Mohoro Commission as well specifically dealt with this matter, indicating that a DPP has no power or authority in another jurisdiction. And I'm not aware that this has happened. I do want to say that special DPPs, that's not a Section 6 DPPs, the SDPPs, who I mentioned earlier, who have, like we have an SDPP in charge of the Sexual Offences Unit, they have jurisdiction over the entire country, and they can assist the DPPs in any part of the country. But that's not a Section 6 DPP. That's a distinction.
Advocate Batohi, will there be circumstances, for instance, where a Section 6 DPP would get into an area of another Section 6 DPP, in other words, in another jurisdiction, and perform prosecutorial duties there?
Not if you haven't been properly appointed as such.
Explain it, how and when it can happen.
If a DPP of one division is also appointed, for example, to act in another division, that is an appointment. So it's a Section 6 DPP. But of course, there will have to be someone in that, the region where the DPP comes from, to be appointed to act there as well. But it's not the instance of a DPP appointed in a specific area. There's never been a case when a DPP of, for example, Northern Cape can exercise jurisdiction over the Free State. So let me also say, when there's a case that's centralized, right? I think I should bring this. There's a section in the Act that allows the National Director to centralize cases. So let's assume there's a matter that starts off in KwaZulu-Natal, and then there's some case charges that are in Johannesburg, in Gauteng. Then the DPP of KZN and the DPP of Johannesburg or South Gauteng will then confer and say, look, in the interest of centralizing this case, because there are legs in our different divisions, we will agree that this case will be prosecuted in one of the two divisions. And that is the instance where both DPPs agree that the matter will be heard in a particular jurisdiction. But in those instances, then that matter will, once it's transferred, resort under the jurisdiction of the DPP of the division where the matter is being heard.
you are referring to centralization.
That is correct. That is a DPP's function. It's one of the prosecutorial functions of a DPP.
Which is authorized in accordance with Section 111 of the Criminal Procedure Act.
Is it Section 111 of the CPA?
Yes,
I'm not sure.
111.
Thought the NPA Act also dealt with it at somewhere.
Yes,
need to find
it
it.
does, but it's read with Section 111 of the Criminal Procedure Act. We don't necessarily have to go into, for the moment, to go into the provisions of Section 111.
Perhaps you should find out whether the advocate has a copy of that provision.
She indicated earlier.
I don't have a
she
copy
doesn't.
of the provision, Section 101 of the Criminal Procedure Act.
I think you may have this copy for now. Let's make it easier.
Thank you, Chair.
I'm advised, Advocate Batohi, that the provision that you're talking about in the NPA Act is 22.3. Yes, 22.3. So if you centralize, it's centralized in terms of Section 22.3 of the NPA Act, read with Section 111 of the Criminal Procedure Act of 1977.
Yes, that's correct. If you look at Section 111 of the NPA Act, of the Criminal Procedure Act, that act has been amended to now reflect 1A as the NDPP having this power. But it seems like the heading in this section has not been amended because it talks about the minister may remove trial to a jurisdiction of another attorney general. So that was pre the formation of the NPA Act in 1998, or the single prosecuting authority, where we had attorneys general that headed up each of the provinces. There was no national prosecuting authority and no NDPP. There was a minister, there was a Department of Justice and a minister. So at that point, it appears that the minister was able to move a case from one jurisdiction to another. But now Section 3 of the Section 22.3 of the NPA Act gives the NDPP the ability to centralize. And if you look at the rest of the content of Section 111 of the Criminal Procedure Act, it is aligned to the NPA Act, but it seems like they just haven't amended the heading.
Do you want to read it into the record? Perhaps you should do so. Section 111.
Section 111 1A of the Criminal Procedure Act says the direction of the National Director of Public Prosecutions contemplated in Section 1791A of the Constitution of the Republic of South Africa, 1996, shall state the name of the accused, the relevant offense, the place at which, if known, and the director in whose jurisdiction the relevant investigation and criminal proceedings shall be conducted and commenced. Is that sufficient?
It's sufficient for the moment, Advocate Patohi, but I want to take you one step or 2 steps backwards. When you were dealing with centralization, maybe to make it incandescently clear, to make it more clearer, it is when an offense is committed in one jurisdiction and another offense is committed in another jurisdiction. And
That's correct.
And you deal with it in terms of Section 111 for convenience. Am I correct?
That is correct. It could be more than one jurisdiction or 2. It could be 3.
Could be.
But you have legs in different parts of the country. And then the DPPs would confer and decide that for convenience,
Yes.
it should be in one division.
Some of us did not understand legs in different parts.
Oh,
So
sorry.
I wanted you to be clear.
Different charges and offenses
committed.
My apologies. Offenses committed in different provinces.
Thank you.
Thank you.
Now let us go to 42 itself.
I beg your pardon?
I'm saying let us go to paragraph 42 itself. You may not deal with that. Go to paragraph 46 on page 24.
Which paragraph? 24.
46 on page 24.
46.
Madam Justice, Madam Chair. Are you there, Advocate Patohe?
I am.
Yeah, as a matter of introduction, you are appointed by the President.
That is correct, as the National Director of Public Prosecutions.
The NDP, the DPP, is he or she appointed by the President? And if so, in terms of what section of the Act, the NPA Act?
That is correct. The NDPP is appointed by the President, as well as the DPPs, which I think is in terms of Section 13. I need to check that. Yes, Section 13, appointment of directors and acting directors.
It follows, therefore, that Advocate Chauke was appointed by the President of the Republic of South Africa
That is correct.
in the position that he's holding now.
That is correct.
Briefly, go to paragraph 49 and just in passing and in a nutshell, just explain those powers that you have in terms of Section 22(1) over the DNPPs, the DPs, SDPs, just briefly. And to also explain this oversight of the NPA.
So,
Oversight of the NDPP, rather, excuse me.
so we have read Section 22(1) into the record. The National Director, in terms of the section, has authority over, it's the entire NPA. So it would be DPPs, well, the Deputy National Directors, the DPPs, Special Directors, ID, the deputies in the divisions or in head office, the Deputy DPPs, prosecutors, and now the IDAC. And all of the functionaries are ultimately accountable to the National Director in terms of carrying out their duties and executing their powers under the Act. I want to, maybe before I deal with that point, just to mention that the oversight of the National Director is over the entire institution, is to ensure that as the prosecuting authority of the Republic, it functions optimally, effectively, efficiently, and in doing so, every member of the prosecuting authority upholds the Constitution and the rule of law in carrying out our core powers, functions, and in terms of the mandate, and that is instituting criminal proceedings. I do want to mention at this point or explain that the DPPs in the division, and I'm not sure if it's carried, I think it's dealt with in a section that does come through under the Directors of Public Prosecutions, which is from paragraph 68 and page 30. But very briefly to mention at this point that although a National Director has overall accountability and is the head of the National Prosecuting Authority, the power to decide, to make decisions to prosecute, the original power to do so lies in the Directors of Public Prosecutions, who are the heads of each of the provincial divisions. And that is very important to understand, because sometimes it's misconceived that the national director decides on prosecutions. The DPPs in each province are the ones that have that power, and the national director cannot and should not instruct DPPs on which cases to prosecute or not prosecute, save for when they relate to priority areas. If there's a focus of corruption, then we can say that is a priority, and we can check to make sure that those cases are being dealt with. But in respect of each case, Chairperson, the DPP decides on whether to prosecute or not to prosecute, and the national director is a review authority.
Madam Chair, you seem to have wanted to address an issue with her. Okay.
Oh, I thought you were indicating to me as well, and I thought I was being rude by continuing. My apologies, Chair. Well, I'm glad to hear I wasn't being rude.
No, proceed, sir.
Thank you, Madam Chair. What you have just spelled out, Advocate Batohi, is autonomy of the Section 6 DPP. It's not so.
Autonomy insofar as decisions to prosecute are concerned. That's correct.
Yes. Which autonomy you're dealing with in paragraph 51 of your affidavit on page 25?
Yes, that is correct. Sorry, let me understand your question before I say it's correct.
Line 3, you're saying such DPPs are not autonomous, but are subject to oversight.
Yes, let me explain that. Autonomous in the sense that they are not a law unto themselves. You know, they fall under the control, and the Act in fact says you operate under the control and direction of the national director. But insofar as the decisions to prosecute, they have the original power to decide to prosecute. But of course, they are part of a prosecuting authority, and they are ultimately accountable to the national director for the performance and, you know, a whole range of issues. They are required to report to the national director and ensure that there is this accountability, clear accountability line to the national director. But I emphasize, in respect of decisions to prosecute, they are autonomous in the sense that they have the original power to decide on whether to prosecute, who to prosecute, for what charges.
So such autonomy that you refer to is therefore within certain defined boundaries.
Sorry, yes, they work under the subject and control of the national director, and there is a section that I think we deal with it in paragraph 58, which we will come to, which deals precisely with this issue.
Tie it now. Let's leap over to it.
Well,
Let's hasten to go to it. Tie it with the issue of autonomy, so that it can be put into perspective.
Yes, sorry. So it starts with. Maybe I could just get to section 55, but dealing with the issue of the NDPP's oversight.
Yes.
It also relates to, as I mentioned in paragraph 51, they required to submit reports in respect of various aspects of the work in the division. And there's at section 24(4)(a) deals of the NPA Act, deals with this aspect as well, in order to ensure that the NDPP can exercise his or her oversight powers. It will also apply in respect of operational, administrative, financial aspects of the division. And then if we move on to paragraph 55, referring to section 23 of the Act, which provides...
Page 27, Madam.
Yes, page 27. Section 23 of the Act provides that Section 6 DPPs are to exercise and carry out their general prosecutorial functions, powers and functions, and I quote, subject to the control and directions of the National Director. And a similar provision is contained in Section 24(3) of the NPA Act in respect of SDPPs, which is not applicable in this case. So then we move on to Section 56, which then seeks to unpack what the control and direction of the NDPP means.
I beg your pardon. It must have been a slip of the mind. It's Section 56.
Oh, it's paragraph 56, my
not
apologies.
section, yes.
So paragraph 56 relates to, begins to deal with the issue of what does subject to the control and direction of the NDPP mean in relation to the prosecutorial powers and functions of DPPs. And then it outlines in the following paragraphs what this firstly does not mean, and that's clear in section 50, paragraph 57. It does not mean that an NDPP can instruct a DPP to prosecute or not prosecute in a given case. But of course, an NDPP is required, may ask for reports, etc., with regard to cases. And in terms of the review process, an NDPP can overturn a decision of a DPP to prosecute or not to prosecute, which we dealt with earlier today. And we then deal with, just continuing with the oversight,
Perhaps before you proceed on the oversight aspect, Council,
yes.
paragraph 52 and 53, before I ask the question, of what relevance are they to our purpose?
Chairperson, I think it just deals with the structure. That's correct. It's not particularly relevant, but explains the structure of the NPA.
What is ONDPP?
Oh, my apologies, Chairperson. That is the office of the NDPP. So let me explain that, Chairperson. We talked about the different business units in the NPA. Well, we talked about one business unit. So let me explain the structure, Chairperson. You have a national director. There are 4 deputy national directors of public prosecutions in the NPA. The deputy national DNDPP is deputy national director. The deputy national director in terms of the NPS referred to in 52 is the National Prosecuting Service. That is the DNDPP. That deputy is the one that all the DPPs report to the national director through this deputy. So this deputy sort of manages all the general prosecutions, the DPPs in all the provinces. The direct supervisor is the deputy DNDPP for NPS. Then the next business unit, there's four DNDPPs. Just for understanding, it's not relevant, pertinent to this case, but the other deputies are a DNDPP that heads up the asset forfeiture unit, a DNDPP that heads up the strategy, operations, and compliance unit. And at the moment, we just have three DNDPPs. There was another DNDPP who was retired and was heading up the legal affairs division, but at the moment there are 3. So those are the 3. And ONDPP is the office of the NDPP.
You earlier on dealt with the question of autonomy in relation to the exercise of discretion, whether to prosecute or not to prosecute. In paragraph 53, the third or the second line, you deal with a matter that seems to be touching on that issue of autonomy of a DPP. Would you explain what that last sentence means, starting from what this entails?
Certainly, Chairperson. What this entails is that DPPs may institute and discontinue. Chairperson, this was an explanation of the structure of the NPS, that's the National Prosecuting Service. And what was being explained there is what is set out in that paragraph is what I was explaining a short while ago, is that the DPPs in the provinces, they carry out their functions subject to the control and directions of the Deputy National Director who's responsible for NPS. So they report to the NDPP through the DNDPP NPS, who's the head of that business unit. Service, that's correct. The NPS. All general prosecutions are conducted in the NPS. The IDAC now is outside of the NPS, but for all intents and purposes now, all prosecutions, except for the IDAC prosecutions, resort under the NPS, and the others are more specialized units, asset forfeiture and strategy and operations and compliance.
Advocate Chauke as the DPP, South Gauteng.
That's not correct, Chairperson. The decision to prosecute or not prosecute is the DPP's. The original power is the DPP. It is more a managerial function and oversight that resorts in the Deputy National Director, who is, of course, has the delegated authority. A DNDPP can act as a national director in terms of the Act and has the same powers, functions, but it depends on what a national director decides will be a specific area for DNDPP. So to be clear, they are not able to direct or instruct a DPP with regard to the prosecutorial, the decisions to prosecute or not to prosecute.
I suppose the problem may be emanating from the fact that we have only a portion of the Mokoro report reflected on that paragraph, and it's confusing.
Yes, and the context perhaps is not clear.
The context is not there.
Yes.
Because if this is correct, that seems to go against what you earlier said about the independence of the DPP.
Let me read this carefully again, Chair. I didn't think that it said that. Just a moment.
Let me just read it aloud. So what this entails is that DPPs may institute or discontinue criminal proceedings and carry out any related functions in their area of jurisdiction subject to the control and directions of the DNDPP.
Chairperson, that's correct. If you consider this exact same language applies to a national director. The DPPs conduct their functions, all their functions, subject, if you look at the Act, the DPPs act under the control and directions of the NDPP. Maybe we should just go to the section. It's section 23, which says that section 6 DPPs are to exercise and carry out their general prosecutorial, that's paragraph 55, their general prosecutorial powers and functions subject to the control and directions of a national director. So that's the same language that we use in paragraph 53 with regard to their relationship to the deputy national director in charge of that business unit. But we then go on to explain what subject to control and directions mean. And maybe I should, in the first section, paragraph 57, it's mentioned that it does not, what does it not mean? And the same would apply to, it does not mean this in relation to their relationship with the DNDPP as set out in paragraph 53. It does not mean that if an NDPP exercises his or her review powers, let me just continue here, review powers of a decision to prosecute or not to prosecute, that he or she acting in terms of these provisions and complying with the procedure or processes prescribed therein, may overturn the decision of a DPP to prosecute or not prosecute. Let me read it properly, Chair. I'm skipping parts of it and it's not helping any one of us.
I'll tell you what my concern is there. It talks to the autonomy of the DPP
That's right.
insofar as the exercise of his or her discretion is concerned.
Prosecutorial discretion, that is correct. And the point made here, Chairperson, is that it does not, firstly, in the first paragraph, it does not mean that that's 57. It does not mean that an NDPP can instruct a DPP to prosecute or not to prosecute any given case. And if you read section 58, if the converse was true, that subject to the control and directions of the NDPP means that an NDPP can, outside the scope of section 1795 of the Constitution and section 22(2) of the Act, NPA Act, instruct a DPP or prosecutor, and the same would apply for a DNDPP, instruct a DPP or a prosecutor to prosecute or not to prosecute. This would render nugatory or undercut the NDPP's review powers over such decisions, which the legislature could not have intended. It would also be inconsistent with the constitutionally enshrined principle that DPPs are responsible for prosecutions in their respective areas of jurisdiction. And we come to the DPP's powers in paragraph 68 in 2 pages, which will clarify maybe this, what appears to be a lack of clarity. From paragraph...
Before you proceed, Advocate, please put my mind at rest that wherever you're going, you are going to help us understand what is contained in paragraph 56 of your affidavit, especially in quotation marks where you say subject to the control and direction of the NDPP as opposed to the autonomy that should be enjoyed by the DPP, so that you clear the confusion and the misunderstanding.
Sure. In order to do that, I think we first need to go to perhaps section 23, section 24 read with section 23 of the NPA Act. If I can just go there. So section 24, and then let me look at section 23 so that I can deal with them properly. If you look at section 20 deals generally with the powers of members of the prosecuting authority to institute and conduct criminal proceedings. Section 23 reads, subject to the provisions of the Constitution and this Act, subject to the provisions, any director shall, subject to the control and directions of the National Director, exercise the powers referred to in subsection 1 in respect of the area of jurisdiction for which he or she has been appointed. And of course, the powers in subsection 1 are set out. Now, if you read section 24, which deals with the powers and duties and functions of directors, it reads, subject to the provisions of section 179 and any other relevant section of the Constitution, this Act, or any other law, a director referred to in section 13 has, in respect of the area for which he or she has been appointed, the power to institute and conduct criminal proceedings. So this power, the original power to do this, is given to the DPP of a division, not to the NDPP. And so the power of the National Director, or let me say the the control and direction of a national director must be read in conjunction with this section, which gives the DPP the original power to conduct and institute criminal proceedings. And as I say in paragraph 58, that this is the case because the national director is a review authority. And so the national director, in order to be a review authority, it would actually, if the national director is actually involved in the decisions to prosecute, then of course you would not be able to conduct your functions as a review authority. So it's got to be the control and direction of an NDPP extends over various aspects of management of the entire prosecuting authority. So, you know, the DPP can submit reports with regard to cases. The national director can query the pace of cases, whether any additional support is needed for cases, look at the performance of the division, look at issues relating to HR, finance, administrative functions. But the function of the DPP, insofar as the power to institute prosecutions, is clearly set out in section 24(1)(a), which gives the DPP that authority. And the Act gives the NDPP review powers over a DPP's decision. So
it is the language in paragraph 53 that is creating a problem there. When you subject the exercise of that discretion under the control and direction of the DNDPP. And that's why I asked, what is the impact of this on the independence of the DPP then?
I accept, Chairperson, that the way it's structured could create that confusion. And my apologies for that, but hopefully it has been clarified.
I have a follow-up question. The provisions of section 24(1), the powers conferred on the DPP, are they exclusive? Because from the reading of the section, I don't see exclusivity, and it takes me back to the issue of autonomy. Is it you interpreting the provisions of the Act, or is it the Act explicitly saying that to us?
Chairperson, it's the Act that is explicitly saying it to us. If you read section 24(1)(a), it states that subject to the provisions of section 179 and any other relevant section of the Constitution, this Act or any other law, a director referred to in section 13(1)(a) has, in respect of the area for which he or she has been appointed, the power to institute and conduct criminal proceedings. So it is explicitly mentioned that that power vests in the DPP.
Thank you, Council. You may proceed, Council.
Thank you, Madam Chair.
In fact, I think you can tie up this section because we're going to adjourn at 4 o'clock in a few minutes' time.
Let me do so. Thank you, Madam Chair. Now, you explained the autonomy of an NDPP, his powers, his or her powers, as set out in section 24. But I want us to take it just one step forward. If you read section 24, you have to read it with section 20. Section 24(1) you have to read it with section 20. The power to institute and conduct criminal proceedings, where a prosecutor or a section 6 DPP can institute and conduct criminal proceedings and even discontinue criminal proceedings. Am I correct?
That's correct.
I'll leave it at that, Madam Chair. For today, at least.
Thank you. Thank you, Counsel. Thank you, Advocate Batoyi.
Thank you, Chairperson.
We are going to adjourn until tomorrow morning at 10 o'clock. Counsel, you'll continue from where you left now.
Yes, Madam Chair, I will do that.
And before we adjourn, may I just address the issue of transcription. I know Council raised it yesterday, and we learned when we adjourned that we had the record yesterday when you adjourned, but there were some errors. I suppose that was brought to your attention when you arrived at the offices. But we will have a continuing or running transcription every day, meaning that you'll get it the following day. Is that clear? And I suppose with all records, sometimes you find names being incorrectly spelled. I've already seen my name is very badly spelled somewhere. But it is okay, we know that I am who I am. To that extent, I think let's take an adjournment to make it possible for all of us to travel to our different destinations timelessly. And tomorrow we start at 10 o'clock. We adjourn.